everyone, and welcome to this Breathe webinar where we're joined today by our brilliant partners, Access to Human Resources. We're very excited to be joined by Dan and Tracey. So I would love now to hand over to Dan to give a little intro.
Hi, good morning, everybody. Welcome to this. It's great to see everybody, that so many people have joined us. I've sat on employment tribunals for 23 years, and what I can say is in that time, pretty much nothing has changed. In terms of the sort of things we're going to be looking at today, how to understand what constitutes an unfair dismissal, how to avoid it, etc., still holds true, and that we still do the same things today and make the same decisions that we did 23 years ago in the same way. So that's good. Nice to have some consistency. We've partnered with Breathe HR for something like just under 11 years now. It's been a great journey. We've seen both of us grow as businesses, and it's a great partnership, and they're a great organisation to work with. And anyway, we look forward to sharing some of our tips and hints and things with you today.
Fabulous. Thank you so much, Dan. And over to Tracey, please, for an intro.
Thank you, Amy. Morning, everybody. So my name's Tracey, and I am the HR Services Director at Access to Human Resources. I've been working in HR for more than 15 years now in a range of different professions and industries across health and fitness, manufacturing, veterinary, educational and pharmaceutical organisations. I've been working with Dan since 2017, started as an HR advisor and then progressed to HR Services Director recently in December last year. So we currently have a team here of HR advisors who I support. We look after or support clients, over 100 different ranges of clients in different industries with their HR needs as and when they need us. And obviously today we're going to be sharing some tips with you to minimising the risk of going to a tribunal. If I do ever get any free time, then I spend it outdoors, and that's either walking with my dogs or being out and about in the garden. So looking forward to talking to you all this morning.
Thank you so much, Tracey. It's lovely to have you and Dan on here with us today. Fab. So over to the agenda. Hopefully you remember what you've signed up for today, but this is essentially what we'll be covering thoroughly. So we'll be talking with Dan first and then with Tracey, but there'll be opportunities to interact with us throughout. And just a friendly reminder as well, do feel free to add any questions to the Q&A as and when you think of them, and we will go through them at the end of the session. So Dan, let's kick off, shall we, with the first poll?
Yes. We're interested really to know how many of you watching today have actually been to an employment tribunal, either to just see what happens or involved in it as one of the participants.
Thank you so much, Dan. Yes, if you could please fill this out now. What we'll do is we will have a look at where you're currently at, or if you have experienced this, you haven't, or maybe you're in a situation where you're actually dealing with it right now. So this advice today is going to be more vital than ever for what you need to do next. I can see people are filling this in, which is great. Thank you so much. We'll just wait for a few more. Fab. They're still trickling in, I can see. Okie dokie. Thank you. That's lots of you who've completed that. So let's have a look where people are at today. There we go.
Excellent. Well, that's interesting, isn't it? So 84% of you haven't had to go to an employment tribunal. So you're obviously doing a lot right, which is great news. Those of you that have will know that ideally it's something, if we can avoid, it's a good idea too. But if we're totally honest, there is no way of being absolutely certain to avoid being taken to an employment tribunal. As you will maybe be aware, employees have rights, and if they believe truly that they have been unfairly treated in some way, then they have the right to have that heard by an employment tribunal, provided they meet the required criteria, of course. So are we ready to move on?
Absolutely. Great. Take it away, Dan.
Okay, so first of all, for 84% of you that haven't have been or are fortunate enough not to have been taken to an employment tribunal, I just wanted to really outline what we do there. We are part of the UK judicial system under the Justice Department. Usually, a full panel is comprised of employment judge and 2 lay members, one either side. And typically those lay members come from a background, one from an employee background, and historically and traditionally, that was someone that came from a trade union membership background. And on the other side, the employer representative was someone who came from the sort of CIPD stroke employer federation type industry. That's changed back when I first joined back in the early 2000s, when it was opened up, actually, the process was opened up to anybody who could apply. And at that point, we were part of the Department of Trade and Industry. Nowadays, since the law changed a few years ago, unfair dismissals tend to be heard by judge alone, unless there are there is a request by the parties for a full panel for some reason, or the situation involves some other kind of claims that require a full panel to be there. So usually, if you go, there'll be either the judge or there'll be a full panel of 3. And we typically hear claims on unfair dismissal, discrimination cases, unpaid wages, breaches of contract, and so forth. And some statistics which really highlights the amount of work that we do is, in the last year that we have the full statistics for, there were over 102,000 cases in the UK, of which 94,000, or just short of that, were new cases introduced in that year. The average award for an unfair dismissal is £13,749. That's the average, but the highest award tends to be the extremes. Tend to be somewhere in the region of 800,000 to 900,000, but they are very unusual cases. Usually, that's the sort of amount that we're looking at. Of course, that doesn't take into account the costs involved in actually going to a tribunal and representing either yourself or having legal representation there. The highest award in that year for a sex discrimination claim was just under £1 million. So that's something to avoid if we can. And the main types of claims, 34, just over a third of cases are unfair dismissal. So if you're unfortunate enough to find yourself taken to a tribunal, the most likely cases that we get involved with our clients or we help with are unfair dismissal claims. And usually things like Wages Act claims where you've not been paid or the employee has not been paid or claims they haven't been paid, and breaches of contract, which tends to be things like notice pay that hasn't been paid, they tend to get attached as part of the main claim. Working time rights and discrimination only makes up 10 to 12% each of the overall claims. So there is a kind of tendency out there sometimes for people to think that there are far more discrimination claims come in than actually do. So what we're going to focus on today are the 2 key things that most of our clients work with us tend to be concerned about and need to avoid is unfair dismissal. So how do you manage your staff effectively in order to avoid or to minimize the risk of doing it in an unfair way? And how do you ensure that you are not applying or managing your staff in a way that could cause a discrimination claim of some kind? And typically these days, we're seeing more and more mental health cases come into the disability side of discrimination. So we'll cover a little bit of that later on. Something else to mention is, of course, you'll be aware, I'm sure, of the new employment bill that's currently going through Parliament, and that is going to introduce far more employee rights from day one of employment, which will come into force next year, where at the moment, you might be aware that an employee has to have a minimum of 2 years continuous service in order to be able to bring an unfair dismissal claim. That's going to change next year, and it will become a day one right for employees to be able to claim unfair dismissal if they believe that they have been treated unfairly in that way. Main types of claims we've covered. The other thing to sort of highlight really from an employer's point of view is that it takes virtually no time or cost for an employee to bring a claim. They can go online, fill out the form, bang, next thing you know, you've got an ET1, which is an employment tribunal claim form, arriving on your desk. And that's when we say, it's all right, don't panic, give us a call and we can help sort it out. But what we can do is to make sure that by managing staff effectively right from the outset of the employee life cycle, so from pre-recruitment through to training, induction and so forth, we can minimise the risk of things going wrong. So here's the next poll that we had, which is always an interesting one. So what we'd like to know is how many of you think that employers win most tribunal claims, and how many of you think that employees win most tribunal claims? So if you could vote now, and again, similar to what Amy said earlier, once we get a good number in, we'll have a look to see what the results are. That's great. Plenty of people are putting an answer in. Lots of you thinking about it. Some of you might be looking at the answer, I don't know. Okay, so we've got about 80% of you now, most of you have answered. So should we have a look and see what we think? Right, 71% of you think employees win most tribunal claims, and 28% of you think employers. So it's a common misconception. The reality is of the claims and the cases that go into tribunal, over 70% of those are won by employers. So that's good news for us all employers out there, isn't it? And as I always say, the good thing about employment law is the Employment Rights Act 1996, for example, actually tells you you are allowed to dismiss employees. It's completely legal to do so. So the employee who automatically thinks, I've been dismissed, ergo it's unfair, because I've really not met that many employees in the tribunal years I've been doing it that thought it was fair. It's not a case of that being the way that it works. It's a case of finding out actually has the employer acted reasonably in the way that they've treated employees. So, but of those people that do lose employment tribunal cases, why is it that they tend to lose them? And the answer is, in 23 years, as I mentioned at the outset, the fundamentals haven't changed. And if you remember nothing else today, one thing I would absolutely like you to remember is that paperwork wins tribunals. You have to have the evidence that shows that what you've done is reasonable and also in line with what you say you've done. And contemporaneous evidence that was recorded at the time is what wins tribunals. So it's no good. I've sat on cases before where the employer's saying, well, you know, I was never told that I wasn't allowed to do that, and the employer is saying, yes, you did. I've told you loads of times. You know, you didn't, and you can't have this toing and froing of an argument. What we need to see is evidence as to when the employee was told what the situation, what the rules were, when the employee was told what would happen if the rules were broken, and that the employee acknowledged receipt of those. So there's no argument. So the more that you can have in evidence, the more likely you are, A, to avoid an employment tribunal, because when the employee goes to a solicitor and says, oh, you know, I think I've been unfairly dismissed, I was sacked last week and it's not fair, and the solicitor says, okay, well, tell me about it, what happened? And the employee says, well, they took me to a meeting, they explained to me what they weren't happy about, they wrote me a letter, and the solicitor is sort of starting to put his head in his hands and think, I'm sorry, mate, but actually, I think you haven't been treated unfairly. But I was sacked, and I didn't do it. And we'll go on to see in a minute, and I'll explain. Actually, the tribunal is not there to decide whether or not the employee was guilty of what they were fired for. Sounds a bit odd, but I'll explain what I mean in just a minute. So, failure to follow a fair process as well, lack of evidence, unfair practices. So obviously making sure that the policies that we have in place aren't accidentally discriminatory in nature. Unlawful deductions, having the lack of contractual right to take money from wages, that tends to end up people in tribunal. And really failing to settle or mediate, I would add into there really failing to nip things in the bud. I sat about a year ago or so on a case involving the Hampshire police. And we had a young lady there who was a police constable, and she was still serving in the force, but we were at tribunal, and this case went on for 8 days. And for 8 days, we had the chief constable, the assistant chief constable, we had various police officers of different ranks in there, we had people at the back, we had solicitors, we had lawyers. I dread to think the cost of that claim and what it must have added up to. And we sat there, and at the end of the first day, we all looked at each other after we'd left the tribunal room, the panel, and we said, why are we here? And we could not for the life of understand why somebody had not sorted this out at an early stage. I know I don't have a lot of time today, but ordinarily I'd love to tell you the full details. So I'll just skip through it, which is that the lady in question, the police constable in question, was pregnant, and she had had some sick leave during her pregnancy. And when she came back to do the return to work interview with her sergeant, he sat down with her and he made a comment which she took exception to. And she didn't like what he said. He made something, I forget the exact words, it's something along the lines of, oh, I'm surprised you were off. I thought you'd have been glowing at this stage of your pregnancy. Just some little silly remark that was really unnecessary. He didn't probably mean anything by it unkindly, but she didn't like it. She thought it was discriminatory, and she raised a grievance. That's the point at which we thought, well, why didn't somebody just sit down and say to him, look, it was not a really sensible thing to say. Why don't you sit down? Let's mediate. Let's sort it out. Let's hear a grievance. Let's resolve it. She just wanted an apology, and she just wanted to move on. But unfortunately, there was a huge amount of what I would term perhaps rank closing, for want of a better expression. And the whole thing escalated and blew out of all proportion, ending up in an 8-day tribunal years later down the line. So anyway, that's an example. Nip things in the bud is a really key lesson to learn about avoiding an employment tribunal. So very quickly, what is an unfair dismissal? Because not everybody understands that. Well, under the Employment Rights Act, if you end someone's contract, you say to someone, I'm terminating your contract of employment, then that is a dismissal. Or if you breach the contract in such a manner that the employee is entitled to consider that their employment has been terminated, that is what we understand to be a constructive unfair dismissal. So that's where the employee resigns, but then says, well, I resign for rights. A silly past example of that might be where the employer decides to make the employee's life so miserable by being horrible to them and bullying them and harassing them and being an awful employer that they have to leave. And that's where you could find yourself, for example, in an unfair dismissal claim, even though the employee resigned. I know I don't have time to go into that in detail, but if anyone's got any questions about any of these points, then please do get in touch afterwards or during the Q&A at the end, and I'll be happy to expand. As I mentioned earlier, the Employment Rights Act 1996, which is still the law under which we consider unfair dismissal and other employee rights in the tribunal, says an employee has the right not to be unfairly dismissed. Great. But the Section 94 right doesn't apply unless the employee has been continuously employed for not less than 2 years. But as I said, that's going to change. If you are taken to a tribunal for unfair dismissal, you have to explain that you dismissed the employee for one of 5 potentially fair reasons. And I've listed those there: conduct, the way the employee behaved; capability, the fact the employee was no longer able to continue their employment for whatever reason; redundancy, the employee's job no longer existed; statutory contravention, interesting one, don't hear this very often, but it's about the fact that it would be illegal to continue to employ the employee. And typically that might be the employee's right to work in the UK ended. And some other substantial reason, SOSR. That's not a right to say, well, I can't think of any fair reason why I got to get rid. I just don't like the employee anymore, so I'm going to say I dismiss them for some other substantial reason. No, it doesn't quite work like that. It's just that the courts recognise that there are, on occasion, very rare occasions, times where it could be fair to dismiss an employee, but it doesn't naturally fall into one of the other 4 fair reasons. But you must have to show the principal reason. Now, if you are going to dismiss someone for their conduct, or if you are going through a disciplinary procedure and you're not happy with an employee's work, their conduct, the way they behave, whatever it might be, then you have to explain that is the reason why you have disciplined or dismissed the employee, and that it falls into one of those categories. And you must then go on to explain how you did it and the fact that you acted reasonably. And I'll come back to that in just a moment. There is a slide here which you can have a look at your leisure later of things which are automatically unfair. So if you dismiss somebody or end somebody's contract of employment for any of these reasons, then it's game over before you even get past the first stage of the tribunal. So how does the tribunal decide whether an employee has been dismissed fairly? And that comes under Section 98 of the Employee Rights Act. Don't worry, there's no test at the end of this. And it basically decides on case law, because the tribunal, the Employment Rights Act just explains that it depends on whether in the circumstances you acted reasonably. So what is reasonable conduct? And the leading case on this, which we still use, and you'll still hear cited today in employment tribunals around the UK, is the case of British Home Stores and Birchall from 1978. So a good old 70s case. And it is the leading case law on unfair dismissal. And what it says is this: in order for a dismissal to be fair for the reasons of conduct, first of all, the employer must genuinely believe that the employee was guilty. That belief must be based on reasonable grounds, and those reasonable grounds must in turn be based on a reasonable investigation in the circumstances. And if you can tick all three of those boxes, you're home. And if you've done your homework, you've done your work before setting out, which I know, Tracey, we're going to talk a little bit about in a while, and you've got everything in place lined up in your business and your organization so that you have all your policies and procedures in the right way, you've communicated those effectively to your employees, you've got records of that, you follow your procedures, etc., you are more than likely going to be able to avoid ending up in an employment tribunal. Most of the cases we hear, and believe me, we hear cases sometimes with organisations like the Hampshire Police Force, for example, and others that have teams of HR people and absolute ranks of legal representatives and solicitors, and they still end up in the tribunal because they haven't followed the basic rules which we're sharing with you today. The case of Iceland and Jones established the principle of a band of reasonable responses. And what that meant is that there is not necessarily one answer to every situation. And as employment tribunal members, we are not allowed to say what we would have done. We have to say, what would a reasonable employer do? And it could be that one reasonable employer might dismiss for a particular offence and another might not. Both could be right. It depends on your consistency of your policies, your procedures, your rules, etc., your particular organisation, and whether that's in line with what a reasonable employer would do. I know I'm rapidly running out of my time, so I'm going to move on very quickly. Key elements of fairness under ACAS, the Arbitration Conciliation Advisory Service. Matters should be raised and dealt with promptly. So it's no good, as happened to me once when a client rang up and said, I've got him. I said, what do you mean? He said, he's committed gross misconduct. I can get rid of him now, isn't he? Because this employee had been someone who was a bit of a pain in the backside for this employer for some time. I said, tell me what he'd done. And he said, he's done this, X, Y, Z. I said, yes, that's gross misconduct. So you need to suspend him and we need to start an investigation and deal with it properly. Oh, I can't do that. Why is that? Well, I need him to go up to Newcastle next week in order to do his job. Well, it's either gross misconduct, meaning it's a summary dismissal matter, or it isn't. So you're going to have to make your mind up. So you need to act promptly. You need to be consistent. It's no good having one rule for one employee and another for another because they're a particularly good employee and you like them. You need to investigate thoroughly. You need to inform employees of the basis of the problem, and you need to make sure that their statutory rights are implemented. And we'll talk. I know Tracey's going to talk a little bit about that in a moment. So those are some of the key elements of fairness in order to make sure that you tick all the boxes and do things right. Quick word about discrimination in the workplace. There are 6 kinds of discrimination, would you believe? There's direct, associative, perceptive, indirect, harassment, and victimization. I don't have time to go into all of those today, unfortunately, as much as I would love to know more about it. But if you've got questions, do get in touch. But it just shows that you do need to be careful about the way that we manage our staff and have the right policies and procedures in place. What is a protected characteristic? It's something, a characteristic of an employee which is protected in law by the Equality Act. And these are the ones that are currently protected: their sexual orientation, their sex or gender, race, religion or belief, pregnancy, maternity, and so on. So if somebody is treated less favourably than other employees on the basis, they believe, of one of these protected characteristics, then that could end up with a discrimination claim in a tribunal for which the 2-year rule doesn't apply. So from day one, an employee who believes that they've been treated less favourably than others on the grounds of their age, for example, could bring a claim to say that's the case and have that heard at tribunal. So that's what we mean by protected characteristics. So I've blabbered on for quite a while. So another poll over to you. What do you think is the single biggest factor that could realistically lead your business or organisation to face an employment tribunal claim? So have a look at those and see if you could answer those and give us an idea what you think. Is it a misunderstanding of or misapplying of dismissal procedures? Is it inconsistent application of your workplace policies, poor documentation of issues, lack of awareness of discrimination laws, etc.? Or any others? If you think of something else, put it in the chat. So if you could do that now, we'll see what we get. There's a few more to think about there, isn't there?
Yeah, definitely. I can see some answers and responses trickling in, so that's good. Well done, Dan.
Right, and because of my time, I think we'd better move on, hadn't we, a bit? So let's have a look to see what you think. Right, half of you, poor documentation of employee issues and decisions. Great, so I think you must have heard what I said earlier. Paperwork wins tribunals and also avoids them. If you've got careful records, that's absolutely true. Inconsistent application, that's also a good answer. I mean, the truth is that all of them can lead to, and the single biggest factor I would suggest, if you had to pick one of those, is the lack of evidence. So making sure that you've got methods and procedures of recording things accurately and correctly in your organisation is a very important thing. And if you've got any concerns about that, then do go back after today and have a look at your procedures and policies and ways in which you manage staff and record these things, and see whether there's something that you could do to improve that. Okay, I think we're coming to the end of my bit. You'll be glad to hear. So after that, we'll be handing over to Tracey. I mentioned most of this earlier, so I'm not going to talk much about this slide because I've covered these things in what I've said so far. So I'm going to stop now and hand over to Tracey to look at some key strategies.
Thank you, Dan. So next up then, everybody, we're going to talk a little bit about how we handle employee issues in the workplace effectively. We're going to look at the importance of early intervention in your workplace disputes and how nipping things in the bud can really help to prevent things from escalating out of hand. Then we're going to look at the importance of handling any grievances or disciplinaries fairly and correctly to ensure that you comply with your legal obligations. This also helps to ensure you deal with things consistently, no matter who you're dealing with. So everybody should be treated fairly, whether it's a brand new apprentice who's just joined you or the managing director. Everybody gets treated the same. And lastly, we're just going to touch on, again, legal dismissals and what's actually a legal dismissal. So moving on, can I just stop for a moment and ask you to consider, what type of a manager are you? Are you confident in dealing with employee issues, poor performance, poor conduct in the workplace? Or are you part of the team, all good mates in the office, and actually you just rather ignore it and hope it goes away? So a lot of the clients that we deal with are the latter. They ignore it and hope it goes away. But what I would say is dealing with issues promptly would really benefit you in the long run. Lots of our managers find that addressing poor conduct or poor performance is really difficult. They don't like those difficult conversations. But if you can address those issues promptly, you'll prevent small problems from escalating into major disputes, disciplinary matters. You'll also preserve good working relationships, and you'll foster open communication, and you'll build trust and fairness across the organisation. You'll also, of course, set the standards in terms of what is and what is not acceptable in the workplace. For example, if you don't manage your sickness absence and there are no consequences for high levels of absence and poor attendance, then you'll probably struggle to correct that poor attendance issues in the long run. The same is true of lateness, of course. If you've got an employee who always comes in late and you say nothing, then nothing's going to change, and he or she will always come in late. That looks unfair to everybody else in the department. So if you are the sort of manager who's friendly with the team and you do find it difficult to address these situations, the more you think about things and the more you want to address things, the harder it's going to become. And that's why we always advise the best solution is to address the issue head on, nip it in the bud, as Dan said earlier. So the employee will then understand that their continued lateness or other poor conduct may be dealt with under a formal disciplinary procedure if they don't quickly take steps to correct it. Managing these situations quickly will also save you time and money because, of course, it may help to avoid a lengthy disciplinary procedure. And also the ACAS Code of Practice states that it's important that these matters are dealt with promptly and that you act consistently. And then finally, of course, prompt action shows that you treat your staff fairly and consistently, which is absolutely key to successful management. So, if you've ever had to deal with a grievance in the past, have you followed a correct procedure? If an employee raises a formal workplace grievance, you need to follow your grievance procedure. If you don't have a grievance procedure, at the very least, you must follow the ACAS Code of Practice. If you don't have a procedure and you'd like one, please do get in touch with us afterwards and we can help you make a bespoke procedure for your business. So as we just alluded to, you should always try to settle the grievance amicably. That's the early intervention coming into play. So you discuss with your employee what's going wrong and you tell them that it's not acceptable. The first step in the formal grievance procedure, if it is going formal, of course, is to acknowledge the complaint in writing. Employers should take all complaints seriously and provide employees with the written confirmation of receipt. So you must document that they've made the complaint and that you've accepted it or acknowledged it, and you must either do that by email or with a letter. Then you need to establish clear communication channels and assure the employee that their concerns are being taken seriously and that how you'll be handling their grievance. So you can supply your grievance procedure to them at that point. After that, you'll need to conduct a thorough investigation. And during this investigation, you need to gather all the evidence and all the facts surrounding the complaint. You'll need to collect and review witness statements, review any documentation relevant to the grievance, gather any other relevant information to enable you to make an informed decision. So ask questions. What happened? Where did it happen? When did it happen? Who saw it happen? Just really probe and get all of the information you can. Following the investigation, you then need to schedule a formal grievance meeting. And this will provide the aggrieved employee the opportunity to present their case and provide all the facts to you. The meeting should be conducted in a neutral and confidential setting to encourage open and honest dialogue. And the employee should be given the right to be accompanied if they so wish. This can be either by a work colleague or a trade union official. And of course, the manager hearing the grievance must remain impartial. Based on the facts and evidence presented at the grievance meeting, the employer needs to make a fair decision as to whether the grievance has or has not been upheld, and then communicate it to the employee in writing. The decision, of course, needs to be objective and should be based on facts and evidence, not personal opinion. So it's not the right thing to have somebody's friend hear their grievance. You must make sure that it's impartial. It's essential to provide clear explanation of the decision to the aggrieved employee and ensure that they understand the process you followed and the reasoning behind it. Finally, of course, if the employee is not satisfied with your decision, they should be given the right to appeal. And if the grievance goes to appeal, a different manager should hear that appeal, somebody who's not been involved to date. The formal grievance procedure is there to protect the rights and well-being of both employees and employers. And by following the ACAS Code of Practice, employees can demonstrate their commitment to fair treatment. Okay. So let's then move on and see what happens when we have a disciplinary. Nobody likes disciplining staff. Everybody finds those difficult conversations tricky to have and doesn't really want to get involved. But if you find yourself in a situation where the early intervention or the informal counselling or informal discussions to try and correct performance or conduct have not worked, then you might find that you have to take a more formal approach. If you don't have your own disciplinary procedure, then again, you need to follow the ACAS Code of Practice to resolve your issues. And again, if you'd like a procedure, please do get in touch with us afterwards. And again, we'd be happy to get a bespoke procedure together for your company. So the first step in a disciplinary procedure is again the investigation. The employer needs to conduct a thorough investigation. They need to gather all the relevant facts and evidence related to the issue. This may include interviewing witnesses, reviewing various documents such as emails, Teams messages, letters, testimonials. They need to basically gather all the evidence pertaining to that particular disciplinary case together. Once they've gathered all of the information, if they find that the investigation highlights that a disciplinary hearing is justified, a disciplinary hearing needs to be scheduled. Now, with a disciplinary hearing, the employee needs to be given 48 hours notice minimum of the disciplinary. We never spring a surprise on anybody. Giving them 48 hours notice will give them the opportunity to prepare themselves. They also need to have the right to be accompanied, again, by a work colleague or trade union official. Try to avoid them bringing a friend or family member, otherwise it may turn a little bit emotional and one-sided. The employee needs to be made fully aware of the allegations prior to the meeting and be made aware of what the potential outcome may be. So we've laid everything out for them. So again, no surprises. If the allegations are so severe that you feel it's gross misconduct and it may end up in a dismissal, the employee needs to know that before going into their disciplinary hearing. In the actual hearing, the employer will present all the allegations and all the evidence to the employee. The employee should then be given every opportunity to respond to the allegation or allegations and defend their case. And this will ensure a fair and impartial evaluation of the situation. Based on the evidence presented, the employer must then make a fair decision regarding the disciplinary action to be taken. So the action may be no further action, a first formal warning, a final formal warning, or even dismissal if it was gross misconduct. And of course, depending on the history of this employee and whether they've had disciplinaries before. But that's a whole other story we can go into another time. The decision should be communicated to the employee in a clear and concise manner, best face-to-face, and always followed up in confirmation in writing. Some people like to adjourn the disciplinary hearing and then try and make a decision and ask the employee back in with a decision. There's no need to put yourself under such pressure to do that. As long as you communicate fairly to that employee when you will get back to them, that's fine. Sometimes, as Dan just alluded to, there's 8 days of information, and there's no way you could make a fair decision having adjourned for 10 or 15 minutes. So if you need to go away and review all the evidence and then come back the next day or within 48 hours or however that might look, that's absolutely fine, as long as you communicate it to that employee. Of course, the faster you do it, the better, because we don't want to leave them stressed and worried about the situation. Once you've made your decision and you have communicated it in writing to the employee, if they disagree with the outcome of the disciplinary procedure, they have the right to appeal. The ACAS Code of Practice advises that employers have to have a clear and transparent appeals process in place to allow employees to challenge the decision. So if it does go to appeal, as per the grievance, you must have an impartial, different manager appointed to hear the appeal, so you come up with a fresh decision. Dan spoke a little earlier about dismissals. So when it comes to handling a dismissal, you must ensure that it's fair and legal. I won't spend too much time on this because we've already spoken about it, but you must have ensured that you followed a fair procedure as per the grievance and disciplinary I've just spoken about, and you also have to ensure that the reason is fair too. So earlier in the presentation, Dan explained about the 5 potentially fair reasons for dismissal, which are obviously your conduct, capability, redundancy, legal contravention, or some other substantial reason. So everything must fall into one of those categories. He also spoke about Section 94 of the Employment Rights Act 1996 and what constitutes an automatically unfair dismissal, to avoid those at all costs. To reiterate, Section 108 of the Employment Rights Act states that it doesn't apply where the employee doesn't have 2 years continuous service. But again, as you know now, this rule is set to change. And under the Employment's Right Bill, which is currently being read in Parliament, there is a proposal to remove the 2-year rule. And that means that you'll have to follow a full and fair process, such as the one we've just discussed, for anybody, any length of service. There'll be more details about that at a later date. So that's a little bit about our processes. And we also spoke about documentation and how really, really important it is to keep documentation. So let's have a little look at record keeping and compliance and how that supports the effective handling of employee issues. We're going to look at accurate documentation and then obviously how we store it, perhaps on online software such as Breathe. So, looking at the reasons employers may lose tribunals, they include following your fair procedure, or the decision to dismiss was not proportionate, but the role of accurate documentation is really important as well. So, lack of policies, such as grievance and disciplinary that I've just spoken about. Lack of clarity of rules means that the employee can claim they didn't understand the expectations of the company. Lack of terms of employment or contracts of employment, which are a day one right. And lack of paperwork, including your meeting notes, your invitations to meetings, your meeting outcome letters. If you're going to a tribunal and you've disciplined somebody for a conduct issue, you must be able to provide evidence of the fact that you invited them to the meeting, giving them the right to be accompanied, setting out the allegations, giving them 48 hours notice. You should be able to provide an accurate account of the meeting, the notes that you will have taken during that meeting, And then you will be able to show them your outcome letter too, which clearly defines the sanction of the disciplinary and the fact that you gave them the right to appeal. So all of this is really, really important. So it's crucial to retain accurate documented evidence of all of your policies, procedures and notes pertaining to any grievance or disciplinary issues. So, how do we keep these records? Employment legislation changes frequently, and so your employment contracts and policies need to be kept up to date. We're expecting more changes in employment law in the near future, and that would include the removal of the 2-year continuous service rule. The right to a contract is a day one right, so ensure that this is issued either prior to that member of staff joining on their first day of employment, and try and make sure you get a signed copy back and retain it in their employee file. It's important that your company policies and procedures are current and available on day one for your new employee so that they can spend some time familiarizing themselves with the company rules and procedures and expectations. And of course, your existing staff are also going to need access to your policies so that they can keep up to date with employment law changes and refer to them as and when they need to. If you've got employees who've been subject to grievance, disciplinary, absence, or even variations of their terms of employment, all of these letters and meeting notes need to be stored safely and confidentially. I think a lot of you listening in today already use Breathe HR, but I also understand that some of you don't. So I'm going to talk a little bit now about using Breathe. And using HR software like Breathe means that organizations can automate tasks like your onboarding, your expenses, even payroll, general record keeping. You've got holiday records, performance review records, sickness absence records. You've got all of this automated on one easy to use system, Breathe HR. And then this frees up your manager's time, cuts out the need for paperwork, and the manager can focus on managing the team and growing the business. Technology in HR also allows you to gather and analyze data. So it may provide valuable insights into workforce trends and behaviors, such as absence patterns. Do you have employees who are always off sick on a Friday? It can also give you access to holiday usage. Have you got somebody who goes for 9 months of the year without taking any holiday? You can review these things on your system and then you can correct. Data privacy and security are key when it comes to handling employees' personal information. And the protection of sensitive employee information is crucial for avoiding data breaches and staying compliant with privacy laws. You also need to consider cyber threats, which are always present. So as an organization, you need to prioritize strong security measures to keep out unauthorized access and data leaks. Breathe can help you with this. HR software solutions like Breathe can ensure that your HR records are stored and GDPR compliant. HR technology such as Breathe allows for centralized storage and management of data, makes it easier to access, update, and analyze your information. By using an online HR system, employees don't need to transfer data between one another. They can just implement updates in real time. Breathe is a self-service portal too, so you can have this on your PC at work or home, your laptop, your mobile phone, your tablet, can access it anywhere. And this gives employees access to information so they can submit their holiday requests or manage their own data. This leaves them feeling more engaged and informed with transparency and accessibility. Finally, an HR system like Breathe will provide you with great audit trails as well. Your policies and procedures can be updated and made available. Mandatory documentation such as right to work in the UK or visas, etc., can be stored safely there. So, talking just a little bit more about Breathe. As I've just said, it helps you to manage your staff records efficiently. It streamlines the HR workflow and keeps your data safe and secure, so you don't need to have those paper copies lying around. You can store your employee records with all the information and documents in one secure central location. The self-service portal allows employees to update their personal details, such as new addresses or next of kin or emergency contact details. You can ensure those are up to date. It's a simple to use holiday bookings process where the employee can just request their holiday on Breathe, which sends a message to the manager so that they can either approve or not, as the case may be. The manager gets to see the holiday calendar so they can see at a glance who's off, and staff can check the calendar before requesting time off to make sure that that time is actually available before they book their time. It's a great performance management tool too. So with Breathe, you can set your employees one-to-ones or probationary reviews or review meeting invitations. That will go straight over to the employee's email, and then they'll know to put that in their calendar to come and have their review meeting with you. There's a great absence management function, and that records and tracks employee sickness, making the absence management procedures transparent and easy to follow. There's also a document management section where you can install your employee-specific documents and manage company policies so that you can update those all-important documents which I've been referring to. As legislation changes and you need to update your employee handbook and policies and procedures, you can simply do that, add the handbook or the policy back onto Breathe and set a read reminder. At that point, you can see who has and has not read your policies and send them a reminder if they're a little bit slow in doing so. This morning, we've spoken quite a lot about tribunals and disciplinaries and grievance and all the glum aspects to managing people. But I would like to just finish off by saying that there's a great part of Breathe 2 which helps you to manage, oops, sorry, I've gone a little bit too fast, helps you to manage.
That's okay, Tracy.
Sorry, Amy.
It's okay. It's a great time to get to the Q&A now. We've got 5 minutes left.
Used too much time. I was just going to tell everybody about kudos because I think how important it is to recognise positivity and good behaviour too. So if you need to talk about kudos or want to know more about it, have a chat with us at a later date. But Amy has just told me now I've got to shut up. So here we go. Thank you, Amy.
You, Tracy. That was brilliant. Thank you so much. All right, let's get to some of the questions we've got lined up. So first one to kick off, Dan, can you terminate a contract of employment because the employee is a poor organisational fit?
Good question. Short answer, no. But the slightly longer answer is there must be a reason why, or potentially fair reason why, the employee is a poor organisational fit. And harping back to the slide I showed earlier, where if you have dismissed an employee, you have to show it is for one of 5 potentially fair reasons, which is conduct, capability, redundancy, some other substantial reason, or statutory contravention, sorry. So I would say to throw that back, I would say, why are they a poor organisational fit? And to try and get down to the understanding of what is it about their behaviour, what is it about their conduct or their performance that is not right, and then deal with it fairly in that way, approaching it from that point of view.
Fab, thank you, Dan. Hopefully that's helped. And then next up, how long should we keep records for past employees?
The rule of thumb says about 6 years is a good length of time. Certain things have specific statutory necessities. For example, tax things need to be kept for at least 3 years, tax records, etc., for pay as you earn and so forth. But 6 years really is a good rule of thumb in order to have the information you might need to deal with any legal challenges that might come your way.
Fab. And next up, we've got a longer one here. So, does the new Employment Rights Act impact on the utility of employee probation periods with the ability of claim unfair dismissal from day one? Most employees I have dismissed have been dismissed during their probation period. That's quite a great question there.
Yeah, it is a really good question. What's being proposed is a new statutory probation period likely to last for around a maximum of 9 months, during which time there's going to be consultation around what sort of procedure would need to be adopted by employers in order to dismiss employees during that period. It'll be more of a light touch process, but it's more likely to be set out in statute as opposed to now, where you've got the ability and the flexibility to be able to dismiss someone on a short service dismissal relatively easily. So we wait to see what that looks like, but that's what we're told.
Brilliant. Thank you, Dan. And next up, we've got, am I correct in saying that if you dismiss someone, you can include their annual leave accrued as part of their notice period if you don't expect them to work their notice, as long as the notice is twice the amount of time as the annual leave?
Do you want to take this one, Tracy? Because I think you had this recently, didn't you?
I did. So if you dismiss somebody, and you're dismissing them obviously under one of the fair reasons we spoke about, normally you would be obliged to pay their notice and any accrued unused holiday or annual leave that they had. Does that answer the question?
I hope so. Otherwise, I'm sure they'll reach out to you, hopefully. Thank you. And just another one. I'm going to try and get a couple more in on the live session now. Someone else has asked, can you dismiss an employee following a failed performance improvement plan?
Yes, as long as you do it fairly. Obviously, the plan itself would have to comply. Either the plan itself would have to comply with the process as set out by ACAS as a minimum in terms of meetings and warnings and so on. And also decide whether it's a conduct or a capability issue. But yes, it's a short answer.
Thank
Current
you.
time to bring an employment tribunal, 3 months is usually the cut-off point following that an employee has to bring a claim, unless the tribunal deem it just and equitable to extend the time limits for some reason, for some people. So if an employee has missed the 3-month deadline, they can apply to the tribunal, asking them to have an extension of time and explain the reasons why, and the employment tribunal will consider that.
Thank you, Dan. Just another one there. For a small business owner with one manager, who would you appoint to conduct the appeal process?
Tracy, you want to take this one?
I can do indeed. So if there's another senior person in the business, you could appoint them. It's difficult sometimes when you have very small businesses. So another senior person, ideally, or of course you could reach out to your HR provider if you're using somebody like Access to Human Resources. We do often help out with cases and meetings if we have to in situations like this.
We have done that. I would say that in tribunals in the past, we have had cases where the employer, where it's a one-man band, as it were, or one-person band, has actually done the disciplinary and the appeal because there was no one else. That will be tested and looked at very, very carefully during the tribunal, but it doesn't necessarily mean it would be unfair if there was absolutely nobody else.
Right. I can see there are a few questions left, but we are out of time now today. So please could you contact Dan and Tracy? I'll also share those questions that I can pull to Dan and Tracy, but do get in touch. There is some information here if you download the slides from today, so you can reach out to them directly. You can trial with Breathe, you can try their courses, anything you need to support you if you are on an employment tribunal journey at the moment. thank you, a huge thank you to Dan and Tracey for joining us today. I'm sure you agree it was an absolutely brilliant session.
Yeah. Thanks for inviting us.
Oh, honestly, it's been a pleasure to have you. And we will hopefully see you all very soon. And do stay in touch and reach out for anything you might need.